My lady, rather unusually, if you'll forgive me, I'm going to pick up my train ticket because it's just fallen out of my pocket
please
and
feel
I
free.
won't get home if I don't.
I was always hoping there'll be a train for you to use it on, Mr. Brown.
I wasn't expecting that, and I'm sorry for that moment of levity.
Now, had you finished with the transcript?
Not quite, my lady. Before I come to answer my Lord's question about how this court is placed compared to the judge, I was just going to come back to one point that I feel, on reflection over lunch, warranted more, and that's at 88.
Yes.
And that's the advice the judge gave about the variability of a child arrangement order. I think I dealt with it by saying that that was accurate statement of the law. I should also have said that therefore feeds into the question of consent, if I am right, that the later exchange is a full and unconditional acceptance or consent, because it would be clear that it was given with an understanding that the child arrangements order would be variable. And that, I think, feeds into the questions that we were both addressed before lunch about sequencing and related orders. My lady, that then takes me back to the next page, E89, and I don't think I need to say very much about it because it's plain that the judicial sequencing was not simultaneous, that the parental order was dealt with first and the child arrangements order was dealt with second. So they were, although they followed on from each other, they were sealed deliberations. That, we say, supports consent, if I'm right about the relevance of that sequencing of the two statements of, then I give my full and unconditional consent. In passing, I should also remind my lady that on the next page, as the judge is in the closing sequence of the hearing, at 90, she does go back to both parties, but to the appellant in particular, to ask if there's anything else they want to add. So, my lady, I know in a sense that those points are there in the transcript anyway, but that's what we rely upon. And we say that, as a consequence, turns on what evaluation you make about the process and about the judge's evaluation of consent. And it's simply a question of whether that was wrong or not. I've made my submission. Yes. The judge was right and within her discretion.
No, well, they're very clear, no less for being crisp.
My lady, there is then the question of, well, what advantage would the trial judge have had over this court? I can't say with any conviction that there was an overwhelming advantage, save that this was communication in real time with a visual relationship between the participants. And that is different from demeanour. She was in a position to assess engagement.
Thank you.
But other than that, I accept
completely
that you have a transcript, you've been able to listen to it. I can't really argue otherwise about that.
Thank you.
My lady, I did want to say something about the fullness of understanding, because it's clear that subsection 6 has three strands. It's lack of condition, it's free, and it's with a sufficient understanding. And we do say it's significant that understanding is not a ground of appeal. This is an appellant who you can take as accepting that she had sufficient understanding as to the law and its provisions, in my respectful submission. And I'm not persuaded that it will assist the court much on that for me to go through the skeleton argument points in any detail orally, but for the benefit of my clients, perhaps I could say this. It'll be plain to you from what you've read why I said at the outset that the appellant was someone who had been on a journey and had expressed different views at different times, and why we say she'd had the benefit of a number of interventions to help clarify her thoughts, including, in particular, legal advice, not just in 2019, but we infer from the nature of the witness statement, and insofar as it's permissible for counsel to address the court as to what his instructions are, from the financial assistance that the respondents provided her to ensure that she got legal assistance in preparing her witness statement. So we say at the least you can infer from the structure of that witness statement that she'd had some help about what the issues were to be addressed from a lawyer.
Well, it's not been submitted by Ms Baisley on behalf of the appellant that she didn't have an understanding, and in fact, I think she would probably say that the very fact of her understanding underpinned her reluctance to agree.
Well, my lady, but that goes to the change, and it goes to the pivotal 6 or 7 minutes. She brought that understanding into the answers that she gave the judge. I'm not going to try and go back into what I'd said about what that translates to, but that position was stated with a sufficient understanding of the law and its consequences in my respectful submission. Outcome.
Now, are you wanting to make an application for an adjournment?
Well, my lady, I do make it, and I do make it orally, and I accept there's no formal application, but I do say the point is sufficiently addressed in the skeleton argument that there's no great surprise about what we're saying about the...
That paragraphs 14 and 15, this is the adjournment so that the children's or a guardian welfare officer can be...
Could participate in what the outcome should be should the appeal succeed. And I make it solely because the outcome affects the child.
Have you given Miss Baisley notice you're intending to make that application?
Informal, no more, and conversation between counsel this morning. I accept that. But it really turns, my lady, on whether you agree with me, that you have your own obligations to the child at this point if you are contemplating setting aside the parental order.
I'd better hear what Miss Baisley says.
Well,
about that discrete issue,
yes.
The question of the application. If you are now making an oral application for an adjournment.
Can I just say, what arguments could one imagine the child making that you haven't made?
Well,
thank you.
I was going to deal with that.
Sorry.
Well, this is the sequence in our respectful submission. If we've reached the point where the parental order was wrong procedurally or substantively, you're exercising your Section 15 jurisdiction, you've got all the powers that the original court had, you are not, in my respectful submission, on an issue about status and legal relationship in the same position that you would be reviewing a welfare determination. If the order is set aside, there is no legal status other than the family that lives with order. There simply isn't. And that is an issue in our respectful submission on which the child has as much to say.
So that's not answering my question. My question is this, that you've set out fully the argument that might be made and that you are going to be making at some point about the impact of the convention on disposal of the appeal if it was successful in substance. My question was, what would be gained by the child becoming a party and having lawyers?
You would have not my assessment and not the appellant's assessment as to what is the right outcome and what is the right state of the law, but an independent view. That's what you would have, and he would have.
It would be a legal question. I mean, can we take as granted that, from a welfare point of view, CAFCAS supported the making of the parental order on welfare grounds? No reason whatever a year later to think that it would be likely to take any different view about that. But essentially, this is a legal argument. So what could be added by another team?
Well, my lord, I suppose if I'm thinking in terms of strategy, we don't know what Kafkas might say on behalf of the child. But the point that we make, and it's either a good point or it's not, is that on his behalf, there are points to be made that cannot be made simply by the adults. And they should be heard. That's the basis for the application. And my lord, I make it because when we go through the case law, it's certainly right to say that if Section 3 of the Human Rights Act translates into an interpretive power that permits an unambiguous provision to be interpreted differently so as to give effect to the convention, that is an argument which the case law identifies as being of greatest significance to the child rather than the adult. That's to say, and perhaps unsurprisingly.
It doesn't alter the argument. I mean, effectively, as I understand it, you're seeking for us to interpret that subsection by striking it out.
Well, by reading in, yes.
Yeah, well, it comes to the same difference. To treat it as if it didn't exist. And I don't understand how, whatever the merit of that submission is, it's made any differently from the mouth of the child or from your mouth.
Well, my lord, in our analysis of the situation, he has, and someone on his behalf through Kafkas, has locus on the consequences of losing any legal relationship other than by dint of the variable lives with order.
You're talking about using it as an opportunity to obtain updating evidence about the child and about the impact on the child. I mean,
my lady, there must be no doubt that everyone who forms part of his social network has been living for the past 13, 14 months.
You've told us that.
But there must be, and that has.
So this is a route to obtaining evidence, isn't it?
Well,
they can't. That legal argument would be the same as yours.
Well, my lady, I don't know, but in our respectful submission, the voice of the child ought to be heard through that mechanism. But that's the application. If the court's against me, then I'll proceed to explain what we say you should do now anyway.
Thank you. Ms Paisley.
Well, on that point, my lady, this is, as my Lord Justice Jackson has said, a legal question. Kafkas could have sought to be made a party to this appeal. There could have been an application to join them. There could have been an application for them to put in a skeleton argument. They had the opportunity to join in, if I can put it that way, and to address any point they saw fit to address, including Article 8 points. That application should have been made. We would have opposed it on the basis that the essential question in this appeal is a legal question, and it didn't require the child to put in separate legal arguments. The court has both sides of the argument and is not likely to have been assisted on this the legal questions raised in this appeal by the involvement of the child through representation. Of course, the welfare arguments that may have to be considered in due course are a very different matter.
We'll rise for a few moments.
It is in green, isn't it? Yeah.
Paragraph 14.
What's Rose?
Mr. Vine, in the event that we allow the appeal on the main point, we will not be adjourning the matter in order to invite CAFCAS to be joined as a party before outcome is considered. So in those circumstances, if you would proceed now with the second part of your,
Thank you, Madam.
your submissions.
First,
Before you do that, before we get into the weeds of it, may I just be clear in my own mind, your starting point, if I may. As I understand it, what you are saying is that the family life, which was undoubtedly established in any event when S went to live with your lay clients, was cemented and solidified by the making of a parental order, such that now that a certain amount of time has expired, the legal routes that would otherwise be available to the appellant should no longer be available, namely an extension of time for an appeal and an appeal.
Marie, that's not what I'm saying.
Good. Well, that's why I'm asking the question, because that's what it felt like. Because I was thinking the first thing is an extension of time for appealing was granted, and it sounds like you're saying that should not have happened.
Marie, that's not the point. The point is...
Right, so give me the starting point.
The starting point is, as matters stand today, there is both family life between the subject child and the respondent parents, and there is both family and individual identities within the family, which amount to private life, as members of a family where the child was born by surrogacy. On the plain reading of the statute, the unambiguous reading of it, the only method for giving effect to that is by the making of a parental order, which, if the appeal has succeeded, can't be made on the basis of consent. But in my respectful submission, you then need to follow through the sequence of consequences. The first is there any other further evidence now that would tend in a different direction? I have one piece of evidence on that. I recognise it forms part of a continuum, and that is the communication between the parties in September of 2021. And my lady will recall, they're not easy documents to read in the supplemental bundle, but there's a transcribed series of text messages, and there's a series of emails where they are, and perhaps one sees, looking back at it, the genesis of disagreement for the first time, but they are negotiating what message the subject child is to have from all of them for the purposes of understanding who he is. And I do say that within that exchange, the appellant does make some very significant concessions as to what role she does and doesn't seek to play, and who she sees herself as, and how she sees the respondents as by reference to the child. Those are all relevant to the question of parental order. But my lady, why? Because she says unequivocally, I do not seek to parent, 100% recognise you as his parents.
So can we just rewind a little? Firstly, before you got onto these communications post the parental order, you said that the identity that had been achieved by the parental order could only be given effect to by making a parental order on a different basis.
Yes.
And I think, inferentially from your sentence, it was different basis other than consent.
Other than the plain reading of consent.
Well, if it's not consent, it's not consent. Other than the statutory consent, because that would have been the stage the argument had reached. So what is then the basis upon which you would be asking for the statute to be
Does this
interpreted?
court now, in the fresh evidence, have consent? That's the first question.
What you're saying, we should look at those communications,
Well, my lord-
14 months ago, and say that amounts to consent, even if
Well,
the consent was not given in a court?
It did after the hearing. My lady, I think that's as far as I can put line one of the
just so we
analysis.
have this, because you haven't formulated this elsewhere that I'm aware of, it's making a parental order on a different basis other than the statutory consent, but instead on the basis of later given consent. Is that
My lord, there are a number of strands to this. The first strand is, does the fresh evidence enable, because if you could, you might make a fresh determination.
Yes, but at the moment, we haven't yet, as I understand it, had from you the target that you're aiming at. I mean, we can work out whether you've hit it or not. But at the moment, could you?
Well, my
I'm
lord,
just trying to.
my lord,
I don't want to be
target
drafting for you. It's but you said making it the order on a different basis.
The target, my lord, is a parental order.
Yes.
Either to
So
uphold
what
this for a
is the
different
basis
reason.
upon which you say the parental order could be made? Reading down.
On the read, well, so that's the second strand to this.
Okay.
Yes, it's this. And the first question is a preliminary one. Is this a proper issue for an appeal court, or is this an issue for a further application or a remitted court? That's the first question. Our submission on that is that because a decision to set aside affects status and therefore the legal basis for family life and private life, in a way that wouldn't be the case if you were reviewing a welfare decision, you have your own positive obligations under the convention to the child and to the members of the family. That's the first point. The next question then would be, well, has any conventional right been breached at all by the plain reading of the domestic statute?
Yes.
Our submission is respectfully yes, because there is no legal mechanism, no effect given to the family life and to the identities that have arisen under the order that was made.
So if we are not any longer applying the criterion of consent, what criterion are we meant to be applying?
Consent not to be unreasonably withheld.
So could you, if we go back, if we may, to the section,
Yes.
and just tell us, redraft it, give us the wording you say should be in that section.
Not unreasonably to be withheld, or not to be withheld contrary to the welfare interests of the child.
Wording of the Adoption Act 1976,
Yes.
the Adoption Act 1958, or whatever it was, and so forth.
My Lord,
wording that has not found its way into the current adoption legislation.
My Lord, I know that's not the wording that the parliamentary draftsman used in these provisions.
But,
Well, or in all
I'm sorry, having, as it were, chased you on this particular point, I don't want to take issue with you for planting your standard, because that was all I wanted to know, was what you stood for.
That's well, my Lord, that is what I stand for, and I'm trying to give you the sequence of decisions that I say respectfully fall to the court. First of all, am I right at all that you have a convention obligation to the family members because this is an order about status rather than welfare? If I'm right about that, is it arguable that the consent provision, which is black or white in its plain meaning, amounts to a breach? And if it does amount to a breach, is it right that Section 3 of the Human Rights Act provides an interpretive remedy that requires you to read Section 54(6) otherwise than its plain meaning? And my Lord, if I can just, again, as I'm planting the standard, explain why this submission is even being made at this point. My Lord will recall some of the decisions that have been made on Section 3. That's to say, if we look at the Rent Act, that plain wording that succession can pass of a tenancy to same-sex couples, despite the express wording of the statute, that if one looks at the question of what was previously a blanket rule on the admissibility of evidence in rape cases, again, plain reading made previous aspects of the relationship between complainant and defendant wholly inadmissible. These are examples where Section 3 has not just permitted, but required the court to construe the section differently. And the reason for that is that the will of Parliament is expressed both in the original statute, but also in Section 3 of the Human Rights Act. And that obligation is twofold. It's both to read the statute consistent, but give effect to it. And on the House of Lords decision, that is the preferable mechanism for addressing a breach of a human right, if it's possible, on the interpretation of the particular provision, so as to give effect to those convention rights. That's what the bringing the rights home objective of the 1998 Act was. So that's the framework.
But the alternative
my lady, my lord,
is a submission that the subsection is incompatible.
Well, that's the alternative, exactly.
Yes, but that's not before us.
We
It's
need
not
the
the-
Attorney General, don't we, if we're going to
Well,
go down that
it's not before you, and that application hasn't
It's not
been
been
made.
sworn in yet, so it's not ready to come.
And in fact, the guidance from the House of Lords is that that's the less preferable remedy. It's only if the
Only
if
if,
the
you
section-
only if you can't that you go there.
yeah, exactly that. So, my Lord, can I start then as a matter of law on why we say in our domestic analysis of this, in the surrogacy context, identity, including identity of parents, so people in the position of the respondents in this case, forms part of both family life and private life, because without being over elaborate, insofar as our courts have analysed that, we appear, in my respectful submission to take a positive view of the importance of identity, of legal relationship, within the framework of what is family life, what is private life, and its protections. That there is, I will hope to show at some point this afternoon, some difference between how we approach that and how the European Court has approached it in jurisdictions where surrogacy is illegal. And so the factual context is very different. And so we will have to look at what's the purpose of the provision and the Act. It's plain that the primary consideration is the consent of the mother, the birth mother. There's no doubt about that. I'm not resiling from that being a fundamental part of the Act. But what I think I can say with conviction is that there are circumstances where, and not being able to find the surrogate is the obvious one, there are circumstances where the statute envisages a parental order being made notwithstanding the consent of the surrogate mother. Now, I can anticipate that that might be viewed as a practical response to a rather obvious problem, particularly in international surrogacy cases, which again, this case isn't. But it is an indication that within the Act, therefore within Parliament's intention, looking at all of it, was to deliver parental orders, and in the circumstance that it defined, certainly under subsection 7, to do so without the consent of a mother. So I'm not arguing for a construction that on every analysis of section 54 is at odds with it. That's the first point on the structure of the statute.
So on the structure of the statute, you say we should insert at 6, the woman who carried the child, the court must be satisfied, the woman who carried the child has freely and with full understanding of what is involved, agreed unconditionally to the making of the order, such consent not to be unreasonably withheld.
Yes. My lady, I'm not going to shy away from that is not the plain meaning of the subsection.
No.
So it only has traction if you are persuaded that the absence of any other way to secure a parental order would otherwise be a breach.
And no doubt you accept it wholly undermines the policy of the Act.
Well, it does, but that policy, by will of statute and section and the Human Rights Act, also needs to be reviewed in the context of the will of Parliament that every piece of legislation prior to the, well, every piece of legislation should be read and given effect to consistent with the Convention. But the 2 points, they're both expressions of the will of Parliament, is the point. And so I think I can take what the domestic law says.
I think you've been quite speedy on this. I'm also conscious that Ms Baisley is going to need to deal with this
Reasonably quickly. Well, my idea, I'm not going to negotiate, but I wonder whether 3 o'clock is a realistic target for...
Oh, no, absolutely. No. I was hoping you weren't going to go for over an hour. So,
oh. You know, not for the first time I've undersold myself.
I certainly wasn't going to cut you off at the knees like that, Mr Bryan. I just want to make sure Ms Baisley has an opportunity.
There are different ways in which your proposal could be achieved. An alternative to the one that my lady has given, which is to add words to the end of 6, would be to add words to 7, which would say it doesn't require the agreement of a person who's withholding their agreement unreasonably.
Yes.
Yeah. So, one way or the other, you would put it in there.
My lady, my lord, that's the phrase that I hope to establish must be read in because there would otherwise be a breach, and it is possible to do so under section 3. I don't think you need any introductions to the transformative natures of a parental order, but I think what I did want you to have in mind is what was said by Mrs Justice Theis. It's first instance, but in my respectful submission, it must be accurate that a parental order is the optimum legal and psychological solution for a surrogate child. Now that's different from whether it can be achieved in domestic law, but as a statement of welfare, it's the optimum solution. The bundle reference for that, my lady, I'm not going to take the court to it unless it does assist, is 523 of the authorities PDF, and it's paragraph 72. It's what Lady Justice Theis called an honest order reflecting the reality of what was intended.
So you gave a page number which,
Yes, I'm sorry.
which I don't have, sorry.
It was electronic page 523.
Well, I think I can explain what may be the problem, which is that the original authorities bundle had one authority left out and was resent with that authority added at the end. And it may be that my lord is looking...
No, I've got 523. It's just the very last page of the
Yes,
entire bundle. Yes.
Yes.
Yes, and your paragraph?
It was paragraph 71 and 72. My lord, perhaps I should have said that this was a dispenser with parental consent, with birth mother consent case, because she couldn't be found, rather than it's a subsection 7 case, rather than a subsection 6.
But you're picking out from 72 something that the former president said. That the optimum legal and
Yes.
psychological solution. But that's a case-specific observation, isn't it? It's not intended to be a statement of principle. There may be many cases, including some in the bundle, where a parental order wasn't the optimum solution for welfare reasons. It's not a test.
Well, my lord, it's not a test, but it's an indication of the value from a welfare perspective of a parental order.
In the right case, absolutely.
This being a case where, on the face of it, the appellant's objection is not to the making of the parental order, it's to the consequences to her legal status of having done so.
Well, it is to the parental order because the making of a parental order deprives her of parental responsibility.
That being a parental responsibility which she is not seeking to exercise.
Well, as long as she has parental responsibility, she can apply for a Section 8 order as of right.
Well, my lady, she can, but she is not, I hesitate to say on the ground, but that her position throughout has been, the problem is the loss of my legal status, not the conferring of legal status on the respondents. She never shied away from that, and I don't say that her position is any easier than the respondents. My lord, I don't need to say very much about what I think my lord said in 2017, or maybe actually it was Lord Justice Macfarlane in Re H, but simply to emphasise the point that as a matter of law, child arrangements orders are not a substitute for a parental order. They're, well, my lord is nodding, that they are, I hope I can say just very quickly, obviously very different beasts with very different consequences for everyone who's living with them, whether they're made or whether they're not made. My lady, the last part on the domestic authorities that I wanted to bring to you is Sir James Mumby's, again, it's not binding on you, but it's his view of how the Article 8 points apply. It's expressed not in the context of consent or dispensing with, it's in consent, it's expressed in the context of breach of the time limit. So it's subsection 3. And I think I can concede that an argument about consent is different from an argument about time limits. That's not the point. The point is what he says, in my respectful submission, correctly, about the importance of identity when one looks at the Article 8 consequences. And that is in the bundle at 159. And the relevant paragraphs, my lady, are 53 and 54.
Would you like us to read those?
Yes, please. I'll take you to the reference to HFEA decision in a minute. The important point in my respectful submission, my lady, is this, is that if he's right, and I say he is, all the identities are relevant. The identities of the parents as well as the child, and they're fundamental. Child Arrangements Order does not give effect to the identity that already exists within this family. And then, my lady, I think paragraph 53 was a statement that he agreed with what had been said in a HFEA decision earlier, and that, in fact, is at 148. Again, this is not on consent, this is on the death of an applicant and what significance that makes. Almost certainly none now, knowing that a single applicant could make their application. But it goes to, at paragraph 148.
Sorry, did you say?
Sorry, I said paragraph 148. I meant paragraph 24 on page 148. And so again, persuasive but not binding authority in my respectful submission. But there is an obligation, at least as far as we construe our obligations under the Convention, for remedies to be practical and effective and not theoretical and illusory. And the short point is this. Unless there is a parental order made on the basis that we are submitting, there is no legal mechanism to give effect to the family life and the identities that already exist and have pertained for some time. My lady, that it will take more than we have time for today to go through each of the French, Norwegian, Icelandic authorities. That's not my purpose, but I do wish to give you a couple of points of distinction about those and then come to Section 3 of the Human Rights Act. All of those authorities are expressed, I hope I can say without gainsay from Miss Baisley, in a context where there is no domestic recognition of surrogacy. It is not possible lawfully to become a surrogate in France, Norway, and Iceland. All but one of those decisions are made expressly on facts where surrogacy arrangements reached or implemented outside of the jurisdiction were done so to defeat the domestic regime. So the first point about those authorities is they are about a factual matrix and a legal matrix which is wholly distinct from here. The second point is, and this will not surprise the court, that all of those authorities in different ways identify the margin of appreciation and identify the requirement to strike a fair balance. Again, the distinction here is that Parliament's already struck a balance between the private interests and the wider public interest, because the surrogacy agreement that the parties in this case reached is lawful. There is a mechanism for securing parental orders to give effect to that surrogacy agreement. So whilst all of those authorities, and this is, I think, the point that Ms Bazley makes in her skeleton argument, say, when you look at the margin of appreciation, when you look at the fair balance between the competing authorities, there wasn't any practical impediment to family life. You could, in one case, you could achieve nationality, and in another case, no one was suggesting removal from the parents. The equivalent of child arrangements orders could be made. But there was a violation in one of those, and that's in the Menacin and France case. The violation was of the children's rights only, and in outline form, the reason there was a violation was not under Article 8 in terms of private family life, but under Article 8 in terms of private life. The children's identities as the children of surrogacy and the legal uncertainties about their status were sufficient to exceed the margin of appreciation that the French authorities had on the facts of their case and on the law in France as it was at the time. So it's important to say that even in one of those cases, which generally are expressions of margin of appreciation and fair balance, identity at least has traction, and a failure to provide identity or a legal safeguard for identity, in that case, in the case of the children only and not the parents, amounted to a violation. I say on the face of it, but in a sense it doesn't matter because we're talking about the facts of this case and our law, that it's hard to see why the identities of the parents wouldn't also be in the balance. And my lady, if the outcome of the appeal is there's no parental order, there is no mechanism that gives effect to identity certainly. And in my respectful submission, arguably family life as well. And certainly the family life that's persisted for a period of time.
Could you just address us very briefly on the significance of anything of adoption in this context? Stress that I'm not suggesting anything. I'm just wanting to understand the submission that you make, which is that there is no possible way in which, if this identity was crucial, that it could be achieved. So what do you say about that?
Well, that's not the identity that the children have had and the child has had and lived with to date.
It involves you in saying that the identity that you're concerned about is identity as a surrogate child.
This is a surrogate family, and that's how...
I understand that, but another way of looking at identity would be membership of a family. And that's not the way you're putting the case. You're putting the case specifically as a surrogate family
Yes.
identity.
Yes,
So being the legal parents wouldn't be enough.
Well,
It's got to be legal parents bracket surrogate.
well,
those
my lady, that's the submission, because the psychology of the family, the way the child is living, I know what his age is at the moment, but the way he's expected to grow up is with a full understanding of what his origin story was. But there is no legal mechanism to give effect to that. And to come back to my Lord's point, well, does that matter if I'm right that a child arrangements order isn't an adequate alternative measure? Might an adoption order be? All of that is also conditional upon consents and future evaluations.
Well, except it can be your consent can be dispensed with.
Yes?
So your objection to section 54(6) doesn't apply to an application for an adoption.
No. But, my lady, the primary submission is the realities on the ground, the nature of the family that actually exists.
Well, on the ground, do help me with this, Mr. Vine, because on the ground, what, as I understand it, quite understandably, the respondents have become accustomed, in their eyes, to being the legal parents of this little boy, and that's what they want to be. And no doubt, in the same way as any other parents of either adopted or surrogate children, they'll explain his origins to him in a child-appropriate way when the time is right. So why would being legal parents under an adoption order, as opposed to legal parents under a parental order, not satisfy their Article 8 private or family rights?
My lady, because the parental order exists in the first place for a reason, which is to give effect to a particular type of parenting in very specific circumstances. It is inherently part of the identity of the family. And adoption is a remedy, of course it is, but it's not a remedy that, well, why do we have the Act in the first place?
Right, so the only order that is a bespoke order for a surrogacy is a parental order.
That's the submission, my Lord, and the absence of the same on the identity of certainly this family and the lives that have been lived already under an order.
Thank you.
So, Mary, that's the submission on Article 8 and its permutations. If I'm right, what, if anything, can or should the court do about it? That turns on whether I am asking you to read in a form of words which is consistent with the objective of the statute and gives effect to the human rights of those affected, or whether I'm asking you to amend a statute. That's really, I'm putting it in short terms, and knowing that the House of Lords gave much fuller judgments on that issue. 4 out of 5 expressed, it seemed to me, that basic assessment of what the test was as a matter of statutory interpretation. And my lady, the submission we make is a very short one. We are the right side of the line in terms of necessary reading in, rather than, to use Lord Rogers' phrase, going against the grain of the statute as a whole, because the grain of the statute as a whole is to enable surrogacy and to provide a legal framework, including in one instance at least, where the surrogate may not consent.
Well, your assertion begs your question, because it would obviously be said that the statute as a whole has the purpose of promoting consensual surrogacy. So
there's a tension there, my lord. There have been moments where there has been consent in my respectful submission, but that's going to depend on what assessment you make of that.
Lord Roger is in which case?
Gaidan and Gaudin
Gaidan, sorry.
Mendoza.
Thank you.
And I did have that.
So Sage 348.
Thank you very much.
Thank you. I'm on old technology for this particular authority. I don't know if it helps to have what the problem was in the case and how they got to the answer, or whether it's more helpful just to be taken to what I say is the ratio, or whether this is...
You must take your own course, Mr. Vine.
Well, my lady, in which case, I'll start at 349, please, and what Lord Nichols says.
Thank you.
And what the problem was in terms of convention rights with the Rent Act. Paragraph 3, Schedule 1, the surviving spouse of an original tenant has survivorship rights. For the purposes of that paragraph, the person who was living with the original tenant as his or her husband or wife shall be treated as the spouse of the original tenant. The upshot of the statutory construction necessary was that that second paragraph must be construed as requiring that to be understood as and or living in a same-sex relationship. So the plain meaning of the particular statute isn't the question. The question is whether, if there would otherwise be a breach of the convention right, it's possible to read in words which would give effect to it. My lady, ratio for Lord Nichols starts at 30 on 355, and this is a long judgment, my lady. There's not going to be time for me to go through every paragraph of this in detail, so I'm perhaps giving you the highlight as we see it. Paragraph 32, in the middle there, section 3 is apt to require a court to read in words which change the meaning of the enabled legislation so as to make it convention compliant. That's, if you like, that's the scope of the power under section 3. The next paragraph is the restriction on it. Not if it would require adopting a meaning inconsistent with a fundamental feature of the legislation. It can't be fundamental of the 2008 Act that consent is the only vehicle for obtaining a parental order, because consent can be dispensed with on a defined ground. So the purpose of the statute, and I don't dissent from the primary provision, I don't dissent from the importance of subsection 6, but the statute viewed as a whole admits orders being made, parental orders being made, on more than just the section 6 ground. My lady, Lord Steyne has, it seemed to me, a slightly different view of it. It's probably not time, but if I can put it shortly, what Lord Steyne seems to be saying is there has, until that point at least, been an assumption that whether it was possible to read into a statute alternative wording had been approached by the courts only on the basis of, one, that the will of Parliament was expressed in the original statute, whereas of course it's expressed in both, and two, that there'd been an excessive focus on linguistic language in the underlying statute.
Would it be help us and help you, Mr. Vine, you would just simply give us a list of paragraphs
Yes.
which we can remind ourselves of in due course. So Lord Steyn is where we went.
Lord Steyn's observations I've just been referring to you are at 40 to 42.
Yes.
And then at paragraph 44 to 46, you have his ratio and his analysis of why in other authorities, some fairly unusual...
at the moment for a list of numbers. Yes. Do you want to give us the
yes,
full
so I
range
think I
of
gave
numbers?
you 44 to 46.
Yes.
And 47 and 48. My Lord, the short version of his ratio is at paragraph 50, in that the court will know the elephant in the room, whether it's permissible or not, whether it's crossed the Rubicon. That's his analysis of section 3. And then I don't think I need to take you to what Lord Millett said, because that's a dissenting judgment. And on this point, he was on his own. My Lord Roger is a ratio is at 108 to 110, and I think in Miss Bailey's Skeleton argument you were also given 122, which is his characterisation is it interpretation or amendation? It's a different way of approaching what Lord Steyn said, it seemed to me, as to whether you've crossed the Rubicon. My Lord, there's not much to be said about Baroness Hale's judgment, but simply the simple reason that on that point she agreed with other opinions. So I hope I've given you the 3 sets of ratio as to why, and I accept counterintuitively, the plain meaning of the original statute may not be the meaning that it's required to be given once to do otherwise in terms of a convention right would lead to a breach. And we say that the sorts of words I was suggesting for subsection 6, or was my Lord Canvas, subsection 7, fit within that regime. If there's been a convention breach, as we say that.
We've got to bear in mind, haven't we, there's a bit of a difference here. That this is a case in which, post-Human Rights Act, the House of Lords was interpreting legislation that had been passed 25 years or more before, and the Human Rights Act brought in discrimination protections and so forth. This is a case in which the provision is under a 2008 Act, where the minister bringing it in will have certified that it was compliant with the Human Rights Act, and Parliament passed it in the days of human rights. So I very much accept the assistance you're giving us as to the test, but we're not really comparing like with like, are we, when we're considering this piece of legislation compared to the 1977 Rent Act?
My Lord, undoubtedly we've got a post-1998 statute, but the question is still whether on its application to the facts of this particular case. And I do stress the point that this family life, these identities, have been lived under this order for 13 months now.
But your proposal is that the statute would be, in inverted commas, amended, even if the child had been living there for 6 weeks. I mean, it couldn't be 6 weeks because you can't make them for 6 weeks, 3 months.
Well, my lady, I'm bridling it amended, I'm saying interpreted, but I'm not seeking to persuade you that your approach to this should go outside the facts of this case. It is the fact that there has been an order which has subsisted, that identities and relationships have been made from that point of view, which is important. And I think I know my clients would have wished me to say more about some of the problems of a child arrangements order, but I think the court accepts the proposition that it's a very different order. My lady, that's the case for reading in the way that we encourage you to do so if the appeal succeeds. I should say that there is already a lives with order.
Oh,
It's tucked in, I've got the reference somewhere, I think it's page 78, but it's tucked in the order that was made on the 11th of August.
Ah.
Yes, it's at page 78, you say.
Yes, thank you, my lord.
Thank you very much.
Anything else? No, thanks. Anything else? No.
Thank you, my lady.
Miss Paisley.
Thank you, my lady. If I might, before dealing with the human rights arguments, just mention one submission that was made before the short adjournment, which seemed to be that had the consent been given in writing on the Form 101, one wouldn't have looked behind it. Well, that might be right if the consent was unconditional and freely given and continued to be. But of course, the scheme of the Act is that a surrogate may object at any point and withdraw her consent at any point. So although if it's given in writing on the form witnessed by the parental order reporter, the court would normally take that as its first face value. Of course, if the surrogate turned up at the parental order hearing and saying, no, I don't agree, she would be entitled to do that. And that's the underlying...
So in the form as well.
Yeah. Yes, indeed. Yes, indeed. But moving on to the other arguments and the arguments about reading in, or as we would say, amendment of the section. First, it's surprising that what is sought, and my lord's already made that point, is to go back to the old adoption position of not unreasonably withholding consent, rather than suggesting that, or making a submission that it should be similar to the adoption legislation. In other words, that consent can be dispensed with if on welfare grounds that's necessary. So we're surprised about that, because bear in mind that the submissions seem to be made on welfare grounds. But be that as it may, in our submission, that would be directly contrary to what the statute was seeking to achieve, which was that because the making of a parental order is transformative, not just of the rights of the applicants in connection with the child, but also of the child in connection with the surrogate, particularly here where the surrogate is also a biological mother, that it was intended that it must be that consent given freely and unconditionally that was a requirement. So
It's part of the child's life story.
Yes.
That this is how you arrived.
Yes.
This is how you ended up with us.
Yes.
And your mother was good about that.
Yes.
Was happy with that.
Yes.
That's the framing.
That's the framing of the statute. That is the ideal scenario. The parental order was made with the willing, unequivocal consent of the surrogate. And bearing in mind that the fundamental nature of the requirement for consent, we submit that it would be an impermissible amendment for the court to read in what it's being invited to read in. And we do submit that paragraph 121 of the Gavin case is helpful on this. Page 383. Because it makes clear that the key to what is possible for the courts to imply into legislation without crossing the border from interpretation to amendment doesn't lie in the number of words that have to be read in. The key lies in the careful consideration of the essential principles and scope of the legislation being interpreted. It's in the middle of the page. If the insertion of one word contradicts those principles or goes beyond the scope of the legislation, it amounts to an impermissible amendment. And that, in sum, is our submission in relation to what the court's being invited to do here. There's no dispute that there is both private and family life between the child and the respondents. We take no issue with the positive obligation on the state to ensure that there is effective respect for and protection of Article 8 rights. But we submit that there is also a significant margin of appreciation in terms of how Article 8 rights are protected, and in particular, on the facts of this case, how parent-child relationships are protected and formalised. And in fact here we have a case where one of the respondents is a legal parent. I accept the other one isn't, but there is that point as well. And Article 8 also incorporates exceptions when it's justified for a state to interfere with Article 8 rights, and we say that where the scheme of the statute is that the surrogate may withhold her consent on any basis, however unreasonable, however might be regarded as contrary to the child's welfare. It's an absolute right. And to read into the statute, to take away that right or to limit that right, we say is not a reading in but an impermissible amendment. And the margin of appreciation has been dealt with in a number of the cases, and of course they're on different facts, and in fact there weren't cases where a surrogate was objecting. But perhaps helpful in this context is AM and Norway. Where the court deals with that issue and the margin of appreciation in particular. And it might be helpful if there is time just to look at that quickly at page 448 in the authorities bundle. This was a male-female couple who'd entered into a gestational surrogacy arrangement in the United States and had obtained a US birth certificate and a passport. They returned to Norway. Child spent equal time with both of them. The child started kindergarten, at which point children's services and kindergartens expressed concerns about the arrangements. And the father, who was the legal parent, stopped all contact. The mother applied to the domestic courts for recognition of her maternity or for adoption. And the domestic court said neither was possible under the domestic law. Parties had missed the time limit under the Temporary Surrogacy Act. A step-parent adoption couldn't happen because the child had two parents, the surrogate mother and the father. The mother couldn't apply for full adoption because this would deprive the father of his legal parenthood. And it also held that for an adoption application to be granted, all the persons with parental responsibility would need to be consent, which was the position under the law. And the father didn't consent. So the mother applied for interim contact, which the domestic courts refused. And the European Court found that there had been an interference with the mother's Article 8 right to respect for her private life. And that the interference was, however, in accordance with law, pursued a legitimate aim and necessary in a democratic society. And the court specifically noted that it wasn't a violation of Article 8 to require the consent of the father to adoption, because that was well within Norway's margin of appreciation. And if I might mention the paragraph numbers that we think are particularly helpful on this point, 131, 132, 133 and 134. And also, within the concurring opinion of Judge O'Leary, which appears at the end of that authority at page 489, dealing with the assertion by the mother, the psychological mother, of her right to adopt the child, despite the absence of consent by the other biological parent, said at paragraph 16, for the court to endorse the existence...
Sorry, paragraph?
Paragraph 16, there's a sort of second judgment by Judge O'Leary
Yes.
after the end of the case. For the court to endorse the existence of such a unilateral right to adopt under Article 8 would fly in the face of well-established case law protecting parents.
Sorry, do you have a page number for us?
Oh, I'm so sorry.
489.
Thank you, Anthony.
Paragraph 16.
Yes. Yes, page 489, yeah. For the court to endorse the existence of such a unilateral right to adopt under Article 8 would fly in the face of well-established case law protecting parents and children from non-consensual or unilateral adoption procedures which break de facto and de jure child parental parent bonds. And we say that what the court is being invited to do here cuts right across the surrogate's absolute right not to consent, to withhold her consent. And the fact of there being limited exceptions where the surrogate can't be found after reasonable efforts, where she's not capable of consenting, really supports our case in our submission rather than detracts from it. And the cases, the other cases, are really on very different facts. In medicine, for example, France did not permit surrogacy at all. So the cases where the court has read down or been prepared to read into the statute are cases where there simply otherwise would be no connection between the child and the parent. And here we have a very different scenario, where there are alternatives. They may not be ideal, but there are alternatives. And of course, as part of the child's life story, no doubt his journey to being in the family he's in would be explained to him. And certainly for her part, the appellant has no doubt that the respondent's views about the child would not be altered in any way. But that, of course, is not the concern of this court, because our fundamental point is it's an unlawful order and has to be set aside. Lady, I wonder if I might turn my back, unless there's anything else that the court wishes me to address. There's nothing from behind me either, my lady.
No, thank you very much indeed. I think my Lord Justice Jackson has a question for you, Mr. Vine.
That's fine. Could I just ask whether you have any response to Miss Baisley's first point in reply, which was something that I wondered about myself but didn't ask you, which was, is there any particular reason why you would seek to read down in accordance with the old adoption legislation or the new? Because I almost before you said it, it's a welfare.
I don't want to say slip of the tongue, but I think probably I can say not very careful thought by me. I think the point I was trying to make is not so much the precise wording, but the ability to read in to give effect.
So
It's a point well
we
made,
can
if I
take,
put it
we
that
can
way.
take your submission to be that you would read down to say that the consent could be dispensed with on the basis that the welfare of the child
yes,
required.
yes, my lord. I accept. I'm properly chided over that, and I accept the thrust of that point.
Thank you.
Thank you.
Anything else, Kate? Thank you very much, Ms. Lyon. Well, thank you all very much indeed. I think that all of the legal advisors, counsel and solicitors are acting pro bono on both sides, for which we are extremely grateful. This is a very important case, both generally from a macro point of view, but far more importantly to both the respondents and to the appellant, and to have had the advantage of such excellent legal representation at no cost must only be applauded, and we are very grateful for all the hard work that's gone into the preparation and the presentation of the case. So thank each of you.
Thank you.
Now, we will of course reserve our judgments. We will hope to have them out reasonably speedily because, again, we're very conscious of the anxiety that awaiting our decision will be causing to each of the parties. They'll be sent out in the normal way in draft. Might I remind you of the new terms of the embargo, which is extremely strict and must be adhered to rigorously. So only those who absolutely must may see the draft. The draft may be is there to deal with typographical, grammatical and other minor issues of fact and not to re-argue the case. In due course, we will hand down the judgments electronically, and we'd hope that any extra matters can be dealt with on paper. If not, we'll take written submissions.
Thank you, Maria. Understood.
My lady needed 2 timings from the transcript for the benefit of
Yes, we did. Thank
the transcribers, and a note, if we could agree it, on subsection 8A, which we'll endeavour to do reasonably quickly.
If someone could give the usher the note on the timings, because that will need to go up to listing straight away, because they will want to deal with that.
Thank you.
Otherwise, but the note, if that could be sent through as soon as you reasonably can, I would anticipate you can agree it.
I think we will.
Excellent. Thank you all very much.